From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Supreme Court begins its new term on Monday, and it could be another blockbuster. The court will hear cases on racial preferences, regulation in the administrative state, interstate commerce, religious liberty, as well as election law, and racial gerrymandering. How's that for a list? The justices are also facing unrelenting efforts by Democrats and the media who are critical of the court's decisions and even questioning the court's legitimacy, plus some reflections on the greatest judge who never made it to the Supreme Court, Laurence Silberman, who died Sunday at age 86. Welcome to Potomac Watch. I'm Paul Gigot of the Wall Street Journal opinion pages, and with me are Kyle Peterson and Kim Strasso. Welcome to you both. Before we get to the Supreme Court, let me start with some reflections and thanks to Judge Laurence Silberman, who died Sunday after a sudden illness. He was a giant of the federal bench from his seat on the D.C. Circuit Court of Appeals, where he sat for more than 36 years. He was a great personal friend to me and a mentor, not just on legal issues, but also on many other things, and certainly a friend of the Wall Street Journal opinion pages. And our pages only this weekend made an appearance with his last speech, which was on the First Amendment, delivered on Constitution Day at his alma mater, Dartmouth College, stirring defense of the First Amendment and a criticism of Ivy League schools that have been impinging on free speech. He was the author of the opinion that was the appellate precursor to D.C. versus Heller, which found an individual right to bear arms in the Second Amendment, not merely the right for a militia to have arms, an historic case that will echo through the decades. He was also a leader in criticizing early the independent counsel statute, finding it unconstitutional, and his opinion was taken up, the argument, by Justice Antonin Scalia in his famous dissent in Morrison v. Olson, where he said, "This wolf comes as a wolf," in the famous phrase about that statute. Many other cases he made his mark. He also made his mark on the Rob Silberman Commission in the mid-2000s, asked by George W. Bush to look into the intelligence mistakes before the Iraq War. The commission found mistakes, but no deliberate desire to skew intelligence, which was a national service, put to rest that partisan canard. He also served in many roles in the executive branch, deputy attorney general, stood up to Richard Nixon on more than one occasion, read J. Edgar Hoover's papers at the request of Congress, found them horrifying, the secret papers, vowed to take them to the secrets to his grave, and indeed he has. Believed in judicial restraint, often spoke with me about the lessons he learned from watching Justice Felix Frankfurter in an era when Democrats believed in restraint, like Byron White, who was appointed by John Kennedy, but lamented that there just aren't that many of those around anymore, Democrats, and that is for sure. His legacy will live on in the many clerks and others who worked for him, those colleagues that he helped to get to the bench, including Justice Thomas, Brett Kavanaugh, who served with him on the D.C. Circuit, and Amy Coney Barrett, who was a clerk. A great loss for the country and indeed for the Wall Street Journal. All right, let's turn to the Supreme Court. Lots of big cases coming up here, two of them on Monday and Tuesday, right out of the blocks, big cases. Kim, why don't you tell us about the first case we're going to hear today about the Environmental Protection Agency and its writ over regulating water?
Sure. This is a case called Sackett v. EPA, and I'm really looking forward to this one, especially on the back of the Supreme Court's decision last term in West Virginia v. EPA, which reined in the EPA's authority that it had claimed sweeping authority to use the Clean Air Act to get into climate change. It pulled it back in that regard. This one deals with the Federal Clean Water Act, and it stems from a very messy opinion that the court issued back in 2006 called Rapinos, in which Justice Anthony Kennedy was the swing vote in that case. And it left very vague and very broad the EPA's authority to define what counts as navigable waters, which the federal government then has authority to oversee given interstate commerce. This particular case deals with a couple, Michael and Chantel Sackett, who have been trying to build a home now on a lot that they bought near Priest Lake, Idaho for close to 15 years.
It's amazing when you think about it, Kim. 15 years.
15 years. 15 years. They have been fighting this. And they were already moving dirt, and in swoops the EPA and the Army Corps of Engineers, claiming that their land actually involves wetlands and therefore it is subject to the Clean Water Act and federal supervision, and that they'll have to get special permits, some of which could cost up to $250,000. And the way that the EPA ended up getting to this was by claiming that their lot is connected to wetlands, although, by the way, it's divided by a 30-foot road, and that those wetlands are then connected to a man-made ditch, which is then connected to a non-navigable creek, which is then connected to Priest Lake, which is a navigable body of water, and therefore the federal government has jurisdiction.
6 degrees of separation from Kevin Bacon, Kim.
Yeah, it is unbelievable. But here's the problem, is Rapinos basically kind of allowed for this sort of sweeping, broad, tortured definition that they have come up with. And so this is a case that's being presented to the court, asking them to clean up that language, be much more precise about what exactly does count as navigable waters, and therefore what is the proper delineation between lands that are governed by the feds and lands that really should be about state authority.
Yeah, it's going to be fascinating with the new majority in place, just how far they will go on these administrative law cases. And if EPA versus West Virginia is a guide, then the Sacketts could be finally in luck for a victory. Kyle, let's also talk about the racial gerrymandering case, which the justices will hear oral argument on Tuesday. This is a case involving Alabama's congressional map.
Yeah, it's a case called Merill v. Milligan, and it involves the redistricting that the state of Alabama did after the 2020 census. The state says that they have 7 congressional districts, and when they got the census data in, they just made some race-neutral adjustments to shift the populations where populations had grown, because congressional districts are supposed to have about the same number of people. But there was lawsuits that were brought in lower courts, and the argument is this, that there's one majority black district in Alabama in the southeastern part of the state where black voters make up a majority of the population, and that comes out to 14% of the state's total. And the plaintiffs here argue that 26% of Alabama's voting age population is black. So really, the state should have been required under the Voting Rights Act to draw 2 majority black districts. And the lower court ruled in favor of the plaintiffs. The Supreme Court in February stayed that ruling. And so now they're taking it up on the merits. And the question really has to do with Section 2 of the Voting Rights Act. And it says that states have to have voting practices that are equally open. They can't be voting practices that give racial minorities less opportunity to elect representatives of their choice. But there's also some contradictory language, because the Section 2 of the Voting Act itself says that this does not create any right to proportional representation. And the Supreme Court's jurisprudence is also a little bit conflicted, because in the 1986 case called Jingles, they bless these kinds of claims of vote dilution. And so they've been hearing these kinds of claims for decades now. And yet the Supreme Court has also said in more recent decisions that people who are drawing districting maps are not really allowed to do that based predominantly on race. It said that that kind of redistricting, gerrymandering is odious, and that strict scrutiny applies. And so Alabama's argument, it seems to me, basically comes down to, if we are required to draw a second majority black district, then we are required to take race into account in our redistricting in a way that would violate all these other precedents.
Interesting that this case, in addition to the one that Kim talked about regarding the EPA, are both, in a way, an attempt to finally get some clarity from the Supreme Court on just what its standard is in these kinds of cases. It's almost a cleanup operation, because the court has only gone part way in defending property rights in Rapinos, and the ambiguous status of the, I don't know if it's Gingles or Jingles, the Gingles test on gerrymandering. So we're going to see if the court can provide some clarity here. Another example of this is the Harvard and North Carolina cases on their admissions policies, Harvard University and North Carolina University admissions cases where the plaintiffs claim bias on the basis of race, particularly against African Americans who do better on test scores for admissions, no denying that fact, but are let in much less frequently than other races. The lower courts upheld the use of race based on the court's Grutter precedents now nearly 20 years ago, but the Supreme Court might revisit that precedent and strike down Harvard's process, Kim. No guarantees of that, but again, this is another example of going back to old and ambiguous precedents.
Well, and speaking of that Grutter case that you mentioned, 2003, was the one in which Sandra Day O'Connor, then on the bench, infamously said that 25 years from now, the use of racial preferences will no longer be necessary. And this was part of the justification, was this was a temporary thing that the Supreme Court was blessing because we needed to make up for some lost time, etc., in which certain races have been denied admissions to institutions in greater numbers. So we'll give this little evening out period, and then it won't really be necessary. Well, here we are. As you said, it's 20 years later. Does anyone really doubt 5 years from now any of these institutions will still be using racial preferences to change this situation? And the court has been hearing cases ever since then on the exact contours of this. Only as recently as 2016, they heard the University of Texas Austin case, Fisher v. University of Texas. Again, a very closely decided case, 4-3, with Anthony Kennedy as the deciding vote. So this is an opportunity for the court to really embrace this question that John Roberts has brought up, which is the separation of us by race is really a kind of sordid manner. We should be having one standard under the law, and it should be race neutral. We'll see if the court finally gets there with this case.